an appeal in the matter of the Mayor and Commonalty and citizens of the City of London and 48th Street Holdings Ltd and another.
Yes, Mr. Falk.
May it please the Court. I appear together with Miss Lean on behalf of the City of London. Mr. Kaninsky and Mr. Wilcox appear for Principled. 48th Street is represented by Mr. Bruton on a noting brief. If I can deal with some housekeeping matters first of all.
Yes.
My Lord should have an authorities bundle running to page 592 electronically fixed with the hard copy. A core bundle running to page 149 that includes the judgment and skeleton arguments. A supplementary bundle that has been amended because there was a mistake in it, which should run to page 114.
Yes.
Supplementary bundle of authorities to meet my Lord's point.
No, we don't have.
We don't have a supplementary bundle.
We have hard copies of those.
So,
Could an electronic copy
of course,
those
we'll
be
make sure
provided?
one gets through to. We'll make sure one gets.
My electronic supplementary bundle is 123 pages. What that's worth.
That was superseded by a subsequent. I noticed a mistake in that, and it was superseded
Okay,
by.
I thought I'd added the most
that
recent
should-
one.
I've got a paper supplemental one, which one runs also to 123.
There's a mistake in that bundle, in that the pagination isn't sequential in some places, and it doesn't include the full witness statement from Mr.
Does it
Black.
end up at 123?
It doesn't end up. It ends up at 114. So we'll have to correct that immediately. I suspect.
this was
Okay.
this was itself version 2. Substituted yesterday.
Oh well, that's
And it the final in it with the statement of Philip Black starting at 115 and ending at 123.
okay. Oh, that's fine. Then in that case, it is the right one. It's my mistake. Thank you. My Lord, we're going to split up the case between Miss Lean and myself.
I'm sorry to be slow. Version 2.
The supplementary bundle, which I now have, and I think you have, ends with witness statement of Mr. Black,
Yes, sir.
115 to 123.
Yeah.
We needn't go into the version history.
Thank you. That was my mistake. I apologise. My own friend and I are going to split up this case. I'm going to introduce the facts, the statutory scheme and its evolution and its purposes, and the case law relevant to ground 1. And Miss Lean is going to make deal with the case law relevant to ground 2. And therefore, I'm going to be largely assuming, with one exception, that the all the Lang ingredients are present here. And then Miss Lean will consider whether that's correct on ground 2. As to timing, we anticipate, subject of course to the view of the court and to the extent of interventions of the court, we anticipate completing our submissions mid-afternoon. Of course, if that your lordships, the court will hurry me along if I'm labouring points unnecessarily.
Yes, we've been given 2 days, which for once seems to us rather a generous estimate. Don't feel collectively obliged to occupy the entire 2 days.
No, of course, and of course, the court will hurry me along if I'm labouring points that are clear to them. If I can just explain how this issue arises. The central point before the court is obviously the efficacy of the rate mitigation scheme, but it arises through a debt claim against only 48th Street for its unpaid rates for 3 months recurring periods when it was the owner of the unoccupied property.
So you're not. There's no double charge in the
No,
charge.
that's right. No. And
Although on your case, it would have been wrong to charge toll.
it would well on our case, Pol was the owner, and therefore it was the owner of unoccupied property, and it was charged on that basis. So Pol was charged unoccupied rates for the 6-week periods, and it paid.
I
those
see what you're saying.
That's
So
why
you say the basis on which you charged Hull was not incorrect.
was not incorrect. Now, obviously, my learned friend says it should have been on the basis of occupied rates. But
Yes, I mean, I suppose it does depend on how far your case goes. Your case does not go to disregarding the lease.
it doesn't go to disregard the lease. We accept the lease is genuine. And so, obviously, the debt claim against 48th Street will turn on the efficacy of the rate mitigation scheme. And therefore, we're seeking declarations as well as the debt against Pol. And it's for that reason that Pol is principally represented here, because it's effectively against its scheme. The case is effectively against its scheme.
Can also just clarify, we're only hearing from Pol.
Yes.
I assume that's simply because of where the financial
Yes. Oh, yeah. Yes.
outcome.
I'm sure that's right. Miss Bruton's here, as below, is on a noting brief.
Yes.
Yeah. So this is the first time the issue of how Ramsay applies to the word occupy has been considered at this level. And indeed, the previous case in the High Court was the first time that it's been considered at the High Court level. The scheme here is a highly value significant one, £500 million principled claims to have saved its clients, and it says it operates it in about 1,000 buildings across the country. And from the city's perspective, it's very important because it costs the city, on our case, it loses the city £35 million or so per annum. Now, the facts are not in dispute, and importantly, and a matter I'll keep on coming back to, but could I take the court, please, to the supplementary bundle, the agreed case summary at page 4 of the supplementary bundle. And you'll see that paragraph 5, Pol is in the business of providing rate mitigation services for unoccupied property. That's Pol's business. And at 9, the fundamental common ground, the placing of the boxes is solely to attempt to generate occupation for the purposes of Regulation 5. The placing of the boxes and their contents in the premises serves no commercial or business purpose, save for rate mitigation, which is the business purpose of Pol. And the benefit of the occupation is solely the claimed rate mitigation benefits. That's common ground, and that's why this went by Part 8 rather than Part 7. There's no witness action in the High Court. Can I set out an opening proposition which I'm going to refer back to multiple times without repeating? For my own friend's case to be correct, it has to be supposed that in legislating to allow local authorities to impose liability for unoccupied rates on all.
You sound as though you're telling us something you want us to write down. So could you just slow down when you say it?
In legislating to allow local authorities to impose liability for unoccupied rates on all property, subject to tightly defined reasonable excuse exceptions, for the purpose of deterring them being unoccupied and encouraging them to be brought into use. That's Hurstwood, paragraph 25. Parliament in 1966, 67 and carried forward in 1988 intended to create and enable a whole new concept, never before encountered, of occupying to occupy, which we say and will demonstrate is a meaningless and contentless tautology.
I think what the judge below called occupation for the sake of occupation.
Or planting a flag, or being in the business of occupation. And Parliament did so to provide an escape from 67% of the liability it was seeking to impose. And thus effectively making 67% of the liability voluntary, in order to facilitate premises being left empty directly contrary to the statutory purposes. And in a nutshell, that's our case. Obviously, it relies on significant elaboration, but that's in a nutshell is our case. Now, this challenge is to this precise scheme with the characteristics in the agreed statement, agreed case summary at paragraph 9. So it's to this precise scheme, and it's not to other schemes where there is another purpose. So in the macro case, there was a purpose of storing the papers, for example. And so it's not a challenge to the macro type case where there was a different purpose. Of course, the court's judgment here, especially on ground 2, may impact the approach to those other cases, but this is not in terms a challenge to those other schemes. As the court would expect, given the £35 million, the City of London is taking an active role in challenging a variety of schemes. And indeed it put them on hold, claims under earlier schemes, as explained in Mr. Black's witness statement in the last 2 paragraphs. But when this litigation was originally issued, it put them on hold because it said we don't accept that these work. And when permission to apply to this court was granted, it put them on hold again because the issue was up for grabs. Now, on top of that, the City of London is challenging a scheme separately in the High Court which combines this scheme and a Hurstwood type scheme. So it's another permutation, it's another whack-a-mole type situation. And separately, it's leading a consortium of local authorities who are assisting a small local authority in Kent to challenge a religious occupation scheme. And the short point is that rate mitigation schemes have become wide-ranging and of significant concern to the City of London. And this one is, from its perspective, the most egregious of them. Hence this challenge chose this one as the first one to attack. Now I'm going to make my submissions under 7 points. And now that I've seen my own friend's skeleton, the judgment, and the point raised by my Lord Justice Bean on on the 2024 regulations, I've reframed what I'm going to say in the light of all of that. So point 1 is going to look at the rate mitigation scheme itself. Point 2 is going to be the most extensive part of my submissions, and is going to look at the statutory scheme, its evolution and purposes. And just to herald what I'm going to demonstrate there, I will show that from the outset and throughout, the statutory purpose of Parliament, not the Secretary of State, was that all unoccupied hereditaments would be subject to full rates unless a reasonable excuse existed. And obviously that leads then to point 3, that this scheme is contrary to those purposes. I'm then going to come to in point 4, to the Ramsay doctrine, to show what it is and how it applies here. And I'm very conscious that my lady and my Lord Justice Holgate dealt with this very recently in their more short case, so I won't be labouring that unless I need to go into more detail. But under the Ramsay doctrine, I'm also going to be making submissions that the historic cases on occupation, which Mr. Klinsky relies very heavily on, do not assist, because they do not address the Ramsay doctrine. And thirdly, I'm going to be showing that the macro line of cases does not address Ramsay, and therefore can't assist either. Fifth point, I'm going to show that the class of cases...
That was the 5th point.
The 4th point was...
Macro is still under 4.
Macro is still under 4, I apologise. The 5th point is the class of cases to which the legislation was intended to apply. And we say that occupy in Regulation 5 and 65.2 means occupation meeting the Lang requirements, but where it is for the sole purpose of triggering Reg 4A afresh.
Sorry, where it is for the sole purpose of
triggering Reg 4A afresh. In other words, creating a new period of unoccupied exemption. And obviously I go back to the headline submission I made, that just can't possibly have been intended. Point 6 is the 2024 regulations. And I'm going to show that they can't be an aid to construction because applying Ramsay, there is no ambiguity. Secondly, they don't fix the meaning of the word occupy. And thirdly, and I will split this into 2 points, but thirdly, that the argument that they can be relied on falls foul of section 65.2 for various reasons. And finally, under that heading, the regulations can't be understood in the way my own friend suggests, because they'd be contrary to the statutory purposes, parliamentary purposes. And then point 7, I'm going to address very shortly some other matters relied on by the judge. If that's a convenient approach, then I'm going to now get into point 1, which is the rate mitigation scheme itself. And I've shown you the headline in the agreed case summary. Could I take the court, please, to paragraph 7 of the case summary, which sets out the scheme in short order. Paragraph A is the initial once the previous tenant or the previous use ceases, the landowner is entitled to the first period of 3 months. So that's not, we're not concerned with that period here. But under B, upon expiry of that 3-month period, a lease is granted to Pol, and contemporaneously a break notice is served, terminating the lease 6 weeks and a day later. Upon the grant of the lease, Pole places boxes and their contents in the premises for those 6 weeks and positively claims to be liable for rates. And then at the end of the 6 weeks, 48th Street goes back into ownership, unencumbered ownership, and they then claim a further 3-month exemption. And then that just keeps going on a recurring basis until a commercial office occupied tenant is found. And if we can move into the detail, I've already shown the court at paragraph 9b that Principled is in the business of rate mitigation, and it's acquired boxes.
Can we call them Pole?
Pole has acquired boxes and their worthless contents, and they put inventory labels on them.
You said worthless contents. Is there any finding of fact about that?
There isn't a finding of fact to that. But if one looks at the point at the finding, the placing of the boxes and their contents, serves no. This is B 9B. No commercial or business purpose save for rate mitigation. So it's not being claimed that it serves any purpose of storage. At 9B of the agreed case summary.
Yes. The reason I ask is I think I may have seen something in the Pole's own literature about the contents.
You did. You did see that, and I'll come to that. That's at page 105 of the bundle. And they say valuable. We press them on that, and that's what led to this agreed statement. The paragraph 9 here is the result of pre-litigation correspondence, narrowing down the issue, to try to make sure we litigated on the correct starting point. And if we go to the supplementary bundle, page 118, I hope I'm going to be referring the report to the right pages. This is where my lady got page 118 of the supplementary bundle. And you see that the head since the introduction of 100% rates, that was in 2007. Ratepayers have sought ways to mitigate.
Where are you looking?
Page 118 for the supplementary bundle.
I'm in the middle of a witness statement.
Mr. Black, witness statement.
Okay, apologies. Page 105 then. Apologies. This is from Paul's website. The 100% regime was the thing that triggered these sorts of schemes, but we see that they occupy for periods of 6 weeks. They claim to store our own goods of value. That claim's not been pursued and has been overtaken by paragraph 9b. And then the boxes are fully manifested and inventoried. They regularly fill over 70% of the space. And the bespoke portal ERIC ensures that the client and the billing authorities are informed of all details at every junction. So effectively the boxes are tracked. They're tracked when they go in, they can prove the tracking to the council, they can prove the boxes were there, and then they're tracked when they go out. But it's for the purpose of telling the billing authority that they were there. So at the end of the first 3-month period, the parties enter into a service agreement, which is in the core back of the core bundle, page 146. At clause 3.2. Clause 3.2, it provides that the lease will be entered into, At 4.3, Pole contracts to occupy for 45 days. Under the headings at the top, section 2, one sees that the professional services fees paid to Pole means the it's the principled fees. The principled fees means the fees charged by us based on a percentage of your gross saving in rates.
We don't have the quote.
We don't have the quote, no. That was asked for in the early stages and wasn't provided. Am I wrong on that? That's my recollection. If I'm wrong on that,
It's certainly not.
it's not in the papers. No. And then if we go back to at 147, right at the bottom, 7.5, we will notify the councils of our occupation dates. And we've seen the fee is based on rate savings, but you can see that again at clause 6.2. And at clause 7.1, if the scheme is unsuccessful, the fees are repayable. If you fail to qualify for a rates void period after Pole's occupation, the fee is repayable. And the agreement can then be terminated in accordance with the provisions in clause 9. Nothing turns on that. We then turn to the lease, and I make clear right at the outset that we are not contending that the lease is a sham. This is a genuine lease, and we see at page 139 that it's for a term of 6 months at a peppercorn. At 5.2.1 over on page 141, hold covenants to pay all rates. And at 8.7 on page 144, there's a mutual break clause to terminate the lease at any time after 6 weeks. And we also see that.
Sorry, which clause is that?
8.7
Thank you.
on page 144.
Yeah.
So at any time, so the lease will determine at any time after 6 weeks, and you can see there's an early vacation clause. If 48th Street requires early vacation, Pole needs 5 days' notice to vacate. And that's the lease, and then we haven't got the break notice in front of you.
Also notice 5.3, the landlord's responsible for paying for all utilities and services.
Yes,
And also in 5.8, an absolute covenant, prohibiting alienation in any form.
any alienation at all.
It's not a lease which would enable someone to sublet
No.
or assign to some occupational tenant.
No, that's right, and that brings me to the point I'm going to make, that it's solely for the purpose of the rate mitigation scheme, the lease is. And my lord might also be interested in page at 5.13. This goes to the position of the landowner, the reletting boards, obviously that's standard. It's the standard to allow reletting boards and to allow people to come in and visit who might take the premises, but it's the combination of the whole thing. The 6 weeks notice, the 5 days early vacation, the no alienation, the not paying for anything other than the rates, and the reletting boards gives you.
I did wonder why bother having a 6 months term. Why not have a term for 45 days?
Well, I wondered that too, but I can't insist on that. But in any event, the whole package is a genuine lease, but it has to be understood in the real world, and the extent to which it impedes on the real world ability of 48th Street to market its property and to try to find a long-term tenant, a proper long-term tenant, it is, in my respectful submission, limited. There's then a break.
It's going to say, so what?
I understand on that point. I do understand that point, and I say that point doesn't actually go very far anyway, whichever way one looks at Ramsay. But it is limited, and I think in my skeleton I say if I have to argue the point, I would argue it, but I don't think it goes very far. The next point is that the break notice is then served contemporaneously. We didn't put it in the papers because we didn't think it added anything. It is served on the same day as the lease is entered into, and so we know at the outset that the lease will end 6 weeks and a couple of days after it commences, and that there's the ability to get the 5 days early vacation. And we then know that the cycle just keeps on repeating itself.
Sorry, the early vacation, I'm finding it a bit hard to see how that fits in with the mutual break.
Yeah,
It doesn't allow vacation in that 6-week period, does it?
I suspect not. I suspect it has to be read as subject to the 6 week.
Yeah.
But then the cycle repeats itself, and you can see this, please, at the agreed case summary, paragraph 7. Apologies. Yes, the agreed case summary, paragraph 7H. The cycle repeats as long as the premises are not leased to others for their beneficial occupation. So in other words, it repeats until they find an office occupier. And the points I make from that, it can be seen from that package and the agreed case summary that the occupation itself serves no purpose. The placing of the boxes itself serves no purpose. The benefit only arises in the future when there is a subsequent period of unoccupation.
Putting that another way, it only arises when occupation under this lease ceases.
Yes. Yes.
But it's at that point
Yes.
that if the scheme works, the exemption applies.
That's right. And the benefit accrues to the landowner for the period of his occupation. It doesn't accrue to POL for the period of its putative occupation.
Sorry, it accrues to
48th
benefit
Street.
of the landlord's non-occupation.
The non-occupation for the period of its non-occupation.
Yes.
Yes. After these 6 weeks. And the benefit is wholly contingent on the scheme being effective. Now, given all that, I wasn't intending to go into how it actually worked here in detail, but for the court's note, the detailed facts on the paradigm case are in Mr. Black's witness statement at paragraph 16. And there's no dispute of fact.
In effect, the benefit which the tenant gets under the lease is whatever the percentage is.
Yes.
But it's a carve out of the amount of money saved by the landlord. in
For the
relation
later
to
period.
that subsequent period of non-occupation.
Exactly, my lord.
It's a derivative benefit.
It's a derivative benefit. Yeah. And that's going to be relevant for my own friend Miss Lean's submissions on ground 2. But just for the court's note, the detailed facts are set out in Mr. Black's witness statements, paragraph 6, and the chronology at the in the call bundle at page 67. And if we can just go to that briefly, the chronology at page 67 of the call bundle. I'm not going to get into the detail, but I'm just going to show the court the recurring. You see, one cycle is from the 15th of February 22, when the lease starts, to the 29th of June, when the next lease starts. So that's one complete cycle. Then there's another complete cycle from the 29th of June to the 18th of November, and then another complete cycle from the 18th of November, or at least attempting to be a complete cycle. And I think at that point, on about the 26th of January, the City of London put its foot down. And when we come to Ramsay, the court will note that there's clearly here a number of preordained elements that were all intended to operate together, all for the sole purpose of triggering a reset. And the court will note that the scheme is carefully designed to meet the black letter law statutory requirements. 6 weeks, 3 months, 6 weeks, 3 months, and occupation as understood in the pre-Ramsay case law.
Well, in fact, what Mr. Justice Carr said, that if you go through the historic cases, they don't actually deal with this situation at all.
Exactly. That's why I'm not going to spend much time on them.
I'm not even sure he actually said what beneficial occupation amounts to.
I think he did. I think he said occupation for the purposes of occupation.
Well, other than that,
Oh,
yes.
no, that is the benefit. That is the benefit. He said planting a flag.
I'm not even sure I understand what that means.
No, well, that's why I say it's a tautology.
Occupation for the purpose of occupation.
I'll come to that in a moment, but that's meaningless tautology in my submission. Now, I need to make 2 further points at this stage, and that is that it's clear from the agreed statement of agreed case summary that the occupation serves no real world purpose, and secondly, that the scheme would work just the same if there was no poll and no lease, if it was an owner-occupier scheme, as was the case in Public Health England. With the consequence that on my own friend's approach, every landowner in the country, when they couldn't find a tenant, could just simply move a few boxes into the hereditamент, leave them there for 6 weeks, move them out again, and claim 67% relief.
I think Paul might disagree with that, but based on the occupation cases.
Well, in the context of I'll hear what my other friend says, but PHE was a case where there was a benefit to the occupation because
yes,
that's a separate
you
question.
said before that you're not attacking, say, Macro.
I'm not.
Public Health England is another case where they did. The records were at least records that they thought they might need to keep.
Yes, they had to keep. They thought they had to keep the records, and so there was a purpose. So that's not within the ambit of this challenge. But the structure of the arrangement there was the landowner doing it itself, not relying on.
Indeed.
That's the sole point I was trying to make there. With the consequence that this would be any landowner wouldn't even need a rate mitigation company to do it; could just do it themselves. That's the.
Well, if the saving, the rate mitigation is a sufficient purpose, does it need to be achieved by a third party?
No. That's effectively the point. If occupy to occupy is all that's required, then it can be by anybody. Just purporting to putting a few boxes in, meeting the Lang tests, saying we intend to put the boxes in, we meet the Lang tests.
Because otherwise the argument is that if the contrary argument would be, yes, it does constitute occupation, provided you have a tenancy, but then rateability is being made dependent on title.
Yes. Yes. So that can't be
a particular form of title.
Yes, that can't be the correct analysis. So that's why I say, and that's why in this respect, PHE was correct that it made no difference that it was an owner-occupier scheme. Now, in the submissions and in the cases the court has before it, there's an issue arises as to purpose versus motive. What's the purpose of the scheme and what's the motive of Pole and 48th Street in implementing the scheme?
Are they different?
Well, they are different. They have been held to be different. Indeed, most recently in Lord Justice Holgate's judgment in Robinson Webster. Perhaps I could turn up Robinson Webster. I'm pretty sure it was Robinson Webster. Yeah. Yes, I'm not sure my skeleton argument managed to catch up with Robinson Webster, but it's in the authorities bundle at page 568. You don't need to look at the facts of this case. It's a Hurstwood type issue, although it wasn't a rate mitigation scheme. It was just who was in occupation under Hurstwood. But 69 is the relevant paragraph. And we see the argument for the ratepayer was that the Supreme Court had stated that its approach was not founded, and I completely accept this, was not founded on the fact that in that case the freeholder's only motive in granting the leases had been to avoid paying rates. And the court went on, if those leases had the legal effect that the leases were not liable for NDR, then the motive was irrelevant. But the purpose or objective effect of a scheme or plan is relevant. And it's the grant of a legal right to possession under a scheme whereby the grantee has no real or practical ability to exercise it, and which has no purpose other than avoidance, does not fall within the true meaning of ownership. And the distinction, therefore, between subjective intent and objective effect is drawn there. On the fact of this case, it makes no difference for ground one, because the object is at least occupy to occupy, to trigger log 5, and it matters not whether the motive is to get the rate savings at the end of it. So I'll hear what my learned friend says on how purpose and motive plays out on the facts of this case, but we say it leads nowhere in the analysis. I'm now going to turn to the statutory scheme, my point 2, and I will very consciously be led by the court if I'm repeating too many points too often, because the scheme is of some historic complexity. Now, the headline starting point, of course, is that this case will turn on the correct purposive construction of regs 4A and 5 and 65(2). Or, as the judge put it, what was the class of facts to which occupy was intended to apply? It's about purposive construction. None of my submissions are based on making any value judgments or on questions of morality or concerned with motive. It's all about the statutory, and indeed what I'm going to show called the parliamentary intent. Of course, people are entitled to arrange their affairs to minimise tax if what they do is within the statutory purpose. That if is the fundamental caveat. Now, the route to arriving at the correct purposive construction is adequately explained in Hurstwood, paragraph 10 and 16. So if the court could just take up Hurstwood, which is at page 426 of the bundle. Obviously, we're going to be referring to this repeatedly, so it might be difficult to have this separately available. And at 438, the court looks at the approach to statutory construction, and none of that in paragraph 10, none of that will come as any surprise to this court. And then at paragraph 16, both interpretation and application share the need to avoid tunnel vision. Particular charging or exempting provision must be construed in the context of the whole scheme within which it is contained. The identification of its purpose may require an even wider review, extending to the history of the statutory provision or scheme and its political or social objective, to the extent that this can be reliably ascertained from admissible material. And of course, in Hurstwood, that's what the court did. The court went back to the original purposes of the scheme, from 1966, and followed it through. So that's the approach I'm going to adopt now. And as I said in my very initial comments, I'm going to show that the parliamentary purpose, not the secondary legislation purpose, not the Secretary of State's purpose, but the parliamentary purpose throughout has been all properties subject to reasonable excuse. And whilst we have Hurstwood open, perhaps I could ask the court just to save having to come back to this later on. At paragraph 25, we see how the court has here analysed the statutory purposes, and it comes to this summary conclusion. I'm going to call this the H25 purpose of the legislation. It is the aim of deterring owners from leaving property unoccupied for their own financial advantage and encouraging them to bring property back into use for the benefit of the community at large. That's the overarching statutory purpose of the scheme.
It goes back to paragraph 22 as well.
Yes, when I come to Hurstwood in detail, I'll pick that up. But yes, the logic flows through all the way through that. And my summary case is that the statutory scheme shows the parliamentary intent that all property subject to reasonable excuses for the paragraph 8 Hurstwood 25 purposes. That's what it's there for. That's what the scheme's doing. And we start, of course, before the 1966 Act, and from this is my skeleton at paragraph 13 and Hurstwood at 20, so it might be more helpful to just look at Hurstwood paragraph 20. Before the 1966 Act, rates were a charge only on occupation, not the owner. And therefore, if there was no occupier, there was no liability. The Local Government Act 1966 introduced the empty rates regime for the first time, and I need to take the court through this with some care. So could we please turn up the authority bundle at 26? Under section 20, a local authority had a discretion as to whether to adopt the scheme. It had to resolve to adopt it, and it had to do it a year in advance and so on. We don't need to look at that. But liability was then set if there was an adoption of the scheme in section 21. And you'll see that right from the outset of this scheme, where any relevant hereditament, and that's defined below in subsection 3 to effectively mean everything, every non-domestic hereditament, where any relevant hereditament in an area in which this section is in operation is unoccupied for a continuous period exceeding 3 months. So that's the Reg 4A, what is now Reg 4A. The person entitled to possession of the hereditament shall, subject to the following provisions, be rated in respect of the hereditament for any relevant period of vacancy. And then section 21(4) is the equivalent to Reg 5. This is Parliament saying that it's Parliament setting out the reset provision, and there's no distinction between wording there and Reg 5. And the rates were set at 50%. We can see that in 21(2). And the statute.
Sorry, where do you see that?
50. It says 1/2. Section 21(2), second line, 1/2.
Thank you.
So we have all property, 3 months, 50%, and statutory reset in 21(4). And the purpose of that is set out at Hurstwood 22 to 23 and 25 that I've already taken the court through. So if I could ask the court just to read those paragraphs, please. 22 to 23. So we see a very clear parliamentary intent as then summarised in paragraph 25. And at the risk of labouring the point, I've asked for the position, introduction of the legislation to Parliament to be provided to the court. And we can see at the supplementary bundle, page 8, what was said to the House of Commons in introducing the legislation.
Sorry, which page?
Page 8, supplementary bundle, page 8, and it's the 4th and 5th substantive paragraphs there, which set out the overarching purpose. And I pick up in particular the current system means that owners have been able to leave buildings empty for a long period without making any contribution to local revenues. One of the things which most people widely recognise as a social anomaly is the failure to rate empty properties in order to prevent people keeping it empty for long periods. its main purpose is to discourage owners from keeping the property vacant. So the main purpose of Section 20, 20 and 22 was to discourage owners from keeping the property vacant, and thus to reduce the waste of accommodation. And we see the same situation in the House of Lords at page 10. And it's at this penultimate paragraph, second line. The government consider that there should be some deterrent to those who leave property vacant in times of scarcity in the hope of getting a higher price or rent. So all of the same piece, waste of property, get it into beneficial use in the interest of the public, stop landlords keeping it empty. And consistent with that overarching purpose.
There's also the point that owners benefit from local services, which is identified even when their properties are empty.
Yes, yeah. But of course, this case here is not concerned with the headline point, although it's within the structure of the headline point. It's concerned with the exceptions. But we can see that that principle of the overarching purpose is reflected in all of the exceptions, and this is a point that the Supreme Court noted in Hurstwood. If the court could look at paragraph 27, all of them tend to reinforce, all of the exceptions tend to reinforce the purposes underlying the legislation. And so we can look at the exceptions in the 1966 legislation, and we can see first of all the 3 months in section 21(1), and that in my submission is clearly to deal with a situation where a property has become unoccupied in the normal churn of the market. Normal turnover of tenants and uses in the market. That exception has carried forward into Reg 4A. There's some other exceptions provided for in 22(3) at page 28, and we can see there the exceptions are the same as what we have now, largely the same as what we have now. The owner is prohibited in law from occupying. That's now 4C. The hereditament is kept vacant by reason of action by the public authority with a view to prohibiting occupation or with a view to acquiring it. That's 4D. The hereditament is the subject of a building preservation order. That's now 4E. The hereditament is the subject of a preservation order under the Ancient Monuments Act. That's 4F. E and F here haven't been carried forward into what we have now. But the short point is that it's all where there's a reasonable excuse for the non-occupation. And when we come to regulation 22(4), you see a regulation making power. And can be, shall not be, the Minister may by regulations provide that rates shall not be payable in respect of hereditants of such descriptions as may be prescribed by regulations, or in such circumstances as may be so prescribed, and the regulations may make different provision for different hereditaments of different descriptions and for different circumstances. And that's now what's in section 45(9). And so the headline point is all property save reasonable excuses, and with the statutory reset in the same words as now. Essentially the same words as now.
I'm just looking at the way, going back to section 21, subsection 4, which you say has a parallel with the regulation.
Yes.
Just the way it's been structured. You've got a relevant hereditament which is unoccupied. It becomes occupied on any and then becomes unoccupied again. Then for the purposes, then the 6 weeks is referred to. Then for the purpose of ascertaining any period of 3 months during which the inheritance has been continuously unoccupied, it shall be deemed, as a deeming provision, to have remained unoccupied on that day. In other words, you're disregarding the period of occupation.
Yes.
If it's
It's a
less than 6 weeks.
Yes, it's disregarding. It's disregarding. So it's aimed to pursue the purposes of the legislation. It's not meant to be a get out of. It's not to get out of the liability phrase. I'll come to that in detail on my submissions on Reg 4 and 5, if I may, in due course. And we know that the regulation-making power in section 21(4) would, of course, have to have been applied consistent with the parliamentary purpose. And we can see that reflected in what was said to Parliament at the time, to the House of Lords. This was at page 10 of the supplementary bundle, right at the last sentence of page 10.
We've just looked at this.
I was looking at the overarching purpose of the scheme generally. Now I'm looking at the exceptions. And then right at the bottom, my right honourable friend has power to make further exemptions and intends to use this power to provide for cases where there is no one immediately in a position to dispose of the property. For example, where the owner has died. And as we'll see in due course, that power was exercised. But again, that's a reasonable excuse. A reasonable excuse for the premises being unoccupied is that the person's died or there's an insolvency situation, which I'll come back to in a moment. The next stage is the 1967 Act, which is at tab 2, page 23.
This is a consolidation.
Consolidation Act. It doesn't. And my short point is it doesn't change anything. Everything carries forward. If it would assist the court, I'll just show where the matters were carried forward. It's just the at page 25. What is now, you can see Reg Reg 4A reflected in 1.1. And then 1.3 is what is now Reg 5. So this was all in Parliament. Parliament was consolidating and just carrying it forward. And I can tell the court we haven't got the rest of Schedule 1 in front of the court, but the exceptions follow the same framework, almost exactly the same framework, with one or two very minor exceptions which don't affect the argument.
So the 1967 Act is consolidated.
It's consolidation, so yeah, and doesn't change anything. But there were regulations made under the regulation making power immediately on its coming into force, so contemporaneous with it. And those regulations, again, they're not before you, but those regulations add in what is now, if we go please to the Reg 4, page 30 of the authorities bundle. Those regulations add in the equivalent of, does the court have regulation 4? The equivalent of G, H, I, J, K, L, and M. So those, again, all reasonable excuse for the unoccupation. And so we can see a consistent theme. All property except reasonable excuse, and that's for the overarching statutory purpose in H25, Hurstwood 25. Then in 1974, we haven't put this in again, it's just referred to my skeleton, it's of only minor significance, it's my skeleton, paragraph 35. The 50% cap was removed, and it was up to the councils as to what percentage to charge. That's just a hardening up of the legislation. And then we get to the current 1988 Act. And my overarching point here is that the overall scheme was moved unchanged into in any of its essential attributes for our purposes into this Act and the accompanying regulations. And there, through that parliamentary change in the structure, there was no indication of any change in the substance or in the meaning of the words or in the parliamentary intent. Parliament was simply changing the structure of the scheme, not the purposes or meaning of it. And if we can turn up the legislation then at page 8 of the authority bundle. I should start, sorry, at page 3 with the occupied liability. This is occupied hereditament liability on any 43(1)(a) on the day the ratepayer is in occupation. So that's the normal for occupation. The liability, obviously, it's 100%. Then 45 is at page 8, and it's triggered when 45(1)(a), none of the hereditament is occupied.
Can I just ask, I know that you made it clear when it became compulsory for councils to charge.
It's here.
It's in this Act, is it? So this is the one.
Yes.
This is the one major change. You would
The
say.
one major change was I was going to come to that in my next sentence, but okay. No, it's fine. The discretion was removed, and we've checked back, and we're pretty sure it was removed in this legislation, which we say is but for the first time. We couldn't find it having been done previously, so that's a hardening of the position again. So if anything,
checking the repeals.
we'd have to.
Well, this is a clean rate rating system, isn't it?
Yes. So,
It would have repealed the General Rate Act.
and,
Plus the 2000. Sorry,
not the 2007
No.
Act. No.
But was there anything between 1967 and just the 1974 Act?
Only 74.
We've changed the cap.
Yeah, and we can't find anything else. So
Repeals would tell you whether there was anything.
we'll check that over lunch. We'll check the repeals over lunch. We hadn't thought of that. But anyway, by this point, the discretion was removed. So that's the point, and that's a hardening of the statutory scheme. But you'll see the power to prescribe in 45(1)(d). It's the power to describe the class of hereditament to which it applies. But of course, that power would have to be exercised in accordance with the overarching statutory purpose, which hasn't changed. So all property except reasonable excuse.
This type of rate, section 45 rate, applies, as you pointed out, where none of the hereditament is occupied.
Yes.
So what happens where you have a hereditament which is partly occupied?
It goes into occupied rates.
And is the whole of it then treated as
Yes.
subject to the full rateable. Well, in a sense, it doesn't make much difference.
it's-
It's 100% in either case.
Yeah, once it's occupied, it's occupied. Once any of it's occupied, it's occupied within the proper meaning of occupied.
As it happens, because it's 100% and of rateable value, generally speaking, it doesn't make any odds.
No, I think that's right. There are some exceptions to that in terms of religious situations and when next in use and so on. And I'll be corrected if I'm wrong on what I've just said. But the overall position is that if it's partially occupied, it's. In fact, I think the word is if
41
all apart. 40.
Page 3, 43, 1
Yes, all or part. Yes, I didn't read the key words. All or part. Thank you very much. Thank you. So when one comes to 45(1)(d), the regulation making power, it has to be construed in accordance with the overarching statutory purpose, and as does 45(9), which is the regulation making power. May be prescribed by reference to such factors as the appropriate national authority thinks fit. So that's just carrying forward the earlier formulation, essentially. And then 45(10) is, without prejudice to that generality, it can be by reference to the physical characteristics of the hereditaments, the facts the hereditaments have been unoccupied at any time, and we say that's the inviting regulation 5, and the fact that the owners of the hereditament fall within prescribed descriptions. But the key point at this stage is that whilst the structure changed and whilst the exceptions are moved all into regulations rather than split between regulations and primary, the overarching purpose and the core elements are all present as a matter of primary legislation. And that the regulation making power can only be used for the purpose consistent with the overarching purpose. We then need to go to 65(2). This is at page 19. It's 65(1) is what gave rise to the Hurstwood litigation. 65(2), whether a hereditament or land is occupied and who is the occupier shall be determined by reference to the rules which would have applied for the purposes of the 67 Act had this Act not been passed. So that's a clear parliamentary intent to incorporate the approach under the previous legislation to the meaning of the word occupied and to the previous primary legislation, including specifically for deciding what occupy means. So you look back to what would have happened under the previous legislation, primary legislation, ignoring any express statutory rules such as those in section 24, which was agricultural premises, and 46A, which was air raid protection purposes. That provision 65(2) is going to be important when I come to Lord Justice Bean's question about the impact of the 2024 regulations.
But if we go back to the 67 Act, I've got a hazy recollection. There's an interpretation provision which applies judge-made law on occupation.
Yes.
Because the term is not defined in the statute.
That's right. So it's all judge-made law. So it includes land. I'm perfectly happy to accept it includes land, but
it might be helpful just to have the relevant provision.
With the relevant yes, yeah, we'll do that. Relevant 67. Yeah. So it incorporates Lang, but it also incorporates Ramsay, because the rules of statutory interpretation in under the 1967 Act included Ramsay, for reasons I'm going to come to, because it's a declaratory principle the declaratory principle applies, and so Ramsay's always been the law. And
Yes, but you don't need section 65(2) to apply Ramsay.
no, you don't.
It's
It's a
It would
self-standing.
apply anyway,
It-
even if we started with the 1988.
Yes, but this I accept that, and indeed I endorse that. But it's a clear indication that Parliament decided you looked back to what would have happened under the previous scheme, not forward to what might have happened under later regulations. And that's going to be important when we come to the 2024 regulation. But the court should be aware that rules is nowhere defined, at least as far as I can tell, and the Lang ingredients, I can't find them ever having been referred to as rules in any of the case law. So, so the rules are any of the principles that would have applied under the 1967 Act, and that includes Ramsay. But my key point here on 65(2) is that it's a clear statement of continuity. It's clearly requiring that the principles that would have applied are carried through. And therefore it's inconsistent with any change to the parliamentary intent. There can't have been any change to the parliamentary intent when making the 1988 legislation when it comes to the word occupy. And in due course, that means we're going to have to go back to what Parliament meant by it, not what the Secretary of State meant by it.
So rules in 1988 Act section 65(2), rules doesn't mean statutory regulation. It means, in effect, the rules of law, rules of the game, including judicial decisions.
Yes, absolutely. That's right. Yeah, so it includes the Lang principles and it includes, I say, the Ramsay principles. Or if it doesn't include the Ramsay principles, then Ramsay principles are an aid to construction of that legislation anyway. Now, the moving of the regulations into, the moving of the reasonable excuse exceptions into regulations rather than the primary legislation doesn't change anything. There's no hint of any, that the moving of them, the change in the form, was meant to change the substance. And then we come to the 1989 regulations, which were contemporaneous with and came into force before the Act. These regulations came into force on the 28th of, the regulations are Authorities Bundle, page 34. They came into force on the 28th of December 89, and the
So this is tab.
tab 6 of the authority.
Sorry,
These came into force on the 28th of December 1989, and section 45 came into force on the 1st of April 1990.
that was the date when the 1988 Act, generally speaking, came into force.
That's right, yes.
The start of that financial year.
Yeah, that's right. So it's all part of a
There were a
contemporary.
lot of these regulations that were passed between 1988 and 1990. And some of them were so badly drafted they had to be amended more than once.
Yes.
But we're not talking. Are we talking tab 6 about regulations which were before Parliament when they were considering the primary legislation?
I see. We can't assist.
Sometimes
on
that happens.
We can't assist on that. We don't know.
You're not making that point. Okay.
But I am making the point that all of the ones that they were repealing by getting rid of the 1967 Act and its regulations come back in. All of them come back in the same words, for the same purposes. So if we run down, we see the 3 months is A, prohibition in law is B, and well, you just keep on going down. I mean, it just And you
Then
see the ones that-
2A is subject to 3.
Yes, and that's subject to the reset. That's the reset. That's what now is Regulation 5, and all the other ones were either in the 67 Act itself or were in regulations under the 67 Act. So it's moved lock, stock, and barrel across. Again, clear indicator that Parliament didn't intend to, and the legislature didn't mean to change anything. There was continuity in this respect, save for removing the discretion, and therefore a hardening of the legislation. We then get the 2007 Act, which we don't need to, we haven't got in the bundle because it doesn't really take us much further, save for increasing it from 50% or whatever council decided it was to 100%. So that again is a clear hardening of the position. And there was no change to the basic structure of.
Sorry to be slow, but just to be clear, going back to when the 1988 Act came into force,
Yes.
as you pointed out, it made unoccupied property rates mandatory, not
Yes.
some sort of local resolution.
Yes.
At that stage, it was 50%.
At that stage it was still 50%.
But was it 50% mandated by the legislation?
It was. It was in
Yeah,
the
there was a-
original
there was a
provision.
formula.
It was in the original provision of section 45(4). So it went back, I think, at that point to 50%. I think, but yes, it was mandatory at that point.
Mandatory, yeah.
And then we get the 2007 taking it to 100,
Mandatory 100%.
mandatory 100%.
Thank you.
And
What's the reference for the mandatory 100%,
the 2007 Act.
which we have at?
We haven't got. We haven't. I think we decided
Sorry,
we're
that's-
conscious not to overload the court.
that's fine.
But we can provide it, of course.
No, that's,
Now, but it is interesting to see the purpose of all of this. And for that, I ask the court to look at the supplementary bundle, page 11. This is the putting it before Parliament. This is House of Lords. The Minister speeches Parliament for this legislation. And in the second substantive paragraph, you see in the second line, the efficient use of property. And over the page,
Goes to the scarcity of land.
scarcity of land,
The effect that has on market prices.
market prices, and on forcing development on greenfield land. We'll see in a moment. It's all about making the
That's
best.
in the next line.
Yeah. And it's to help force down rents. You can see that at further on, to help force down rents.
Where's that?
At a time when the office rents
Paragraph.
sorry, the second paragraph. Why should they be subsidised to keep property empty at the expense of taxpayers elsewhere at a time when UK office rents are amongst the highest in the world? Then fourth paragraph, rating of empty property should reflect today's social and economic realities. Kate Barker's report to encourage more efficient use of land.
That was all to do with the supply of housing land, wasn't it?
No, it was much wider than that. It was included. We'll see in a moment. It included industrial land. And we see the introduction at this point of empty rates liability for industrial premises for the first time. Previously, they'd been left out because it was thought that it was difficult to get new occupations. And the Barker review, this is page 12, second paragraph. Barker demonstrated in her report that there is no inherently greater risk of different types of property falling empty. So it is right that we should have convergence between industrial and other property.
Sorry, where are you reading from?
This is from page 12, second substantive paragraph.
Okay, yes.
Barker, it's the second line.
Yeah.
So, and we'll see in the regulations that you get here, the industrial property came in for the first time with a 6 months exemption.
It may not matter, but you took us to the 66 Act previously, and Section 21 included a factory.
Yeah.
And as I say, it may not matter.
Okay. I'm conscious that I may have made a mistake there.
But in any event, industry is brought in, and it gets the exemption is different.
It's for 6 months.
It gets a 6 months exemption
Because, yeah, but it was,
maybe more difficult to let.
and we see it at the end of the Minister's speech to Parliament on the fourth paragraph, sorry, on page 13. The benefits of this bill have far-reaching and important consequences for businesses and communities. It signals a step change in the use of valuable property. At a time when the scarcity of land and buildings is a well-recognised problem, here is a bill that incentivises us to maximise our existing assets and to harness those assets for the benefit of the community and wider society. Again, a clear confirmation of the underlying statutory purpose in primary legislation. And one further reference on this, it's the if we go to page 19 of the authority of the supplementary bundle, this is the explanatory memorandum to the regulations.
Yes, what we've just been looking at, we haven't had a pucker and heart debate, so the explanatory note is more conventionally what we should look at.
Yes, I accept that. But, well, if we look at paragraph 7.3, we get the previous permanent right at the end.
So can you give me the page again?
Page 19,
Sorry, big pardon. Thank you.
supplementary bundle, page 19, paragraph 7.3. This is the new 6 month exception in respect of industrial properties, replaces the previous permanent exception in support of the government's policy of increasing the supply of such properties.
So this is taken from a memorandum laid before Parliament. We have the regs, is it?
This is the explanatory memorandum
One way, help on that.
Yeah.
Yes.
by command of
Help.
But again, so no change to the basic structure and a hardening of it for the same purposes. No change to the structure, but hardening of it for the same purpose. And as we're going to see in a moment, it's ironic that that hardening of the purpose led for the first time to these sorts of rate mitigation schemes. So Parliament was getting stricter, but the High Court here says that it must have been opening the door to rate mitigation. We then get to the 2008 regs themselves, and they are at, as they currently stand, are at page 29. And we see at page 30,
Sorry,
regulation
back to the other one.
apologies. At page, this is the authorities document. We see Reg 3 prescribes all different subject to exemptions, so entirely consistent with the previous approach in the primary legislation. And then we see Reg 4A is the continuation of the previous exemption, and Reg 5 is the continuation of the reset provision. All in, for our purposes, exactly the same terms.
I noticed in Reg 5 it doesn't use the word deemed, but as another word, shall be treated as having.
It doesn't make any difference to the same approach, it's just updating the language. And all the other exceptions get carried forward with only minor changes. And if we can then go back to Hurstwood to see what the Supreme Court has made of all of this, at Hurstwood 25 to 26, it's effectively that they're all readily explicable as having a reasonable excuse. Hurstwood 25 to 26, if I could ask the court to read those two paragraphs.
You've been referring us rather liberally to Hansard extracts, but it's not very controversial in this case because it's set out in Hurstwood, and you're certainly entitled to refer to that if it was good enough for the Supreme Court. It was good enough for us.
Yes. And all I'm showing, my lord, is that I'm using the background material to show that what I say is what the legislation itself is doing is what Parliament thought it was doing.
But you're using it to identify explicit purposes.
Yes.
As opposed to a minister saying this is what the words mean.
Yeah. Yes. It's to establish the underlying statutory purpose, the overarching statutory purpose. So the Supreme Court is basically, and I'm paraphrasing, of course, and it's more sophisticated than this, but all of them are either where you can't occupy, or you've got a reasonable excuse, or there's some other valuable contribution. And I paraphrase all of those as.
It actually picks up. The judgment picks up 4A and 4B just above letter D.
Yes, which have been unoccupied for short periods. It doesn't take, my own friend's dead right, that it doesn't take us any further. It doesn't tell us any more about the purpose of Reg 4A and 4B because that wasn't the key issue in that case. And it doesn't tell us anything about Reg 5 either, the judgment doesn't. So I now come to the meaning and purpose of Reg 4A and Reg 5. And I say that they have to be understood consistent with the overarching parliamentary purpose in H25. And that means that the exceptions can only apply where there's a reasonable excuse, my shorthand, reasonable excuse, and that there isn't some freestanding power to grant exceptions contrary or inconsistent with the statutory purpose, the overarching statutory purpose. And that short point is central to any purposive interpretation. And therefore, when one looks at Reg 4A, it is addressing the normal turnover of tenants or uses in the real world.
It's point another way. If the RMS is compatible with the statute, is there any limit as to the length of time for which you can carry on recycling?
No. No, you just keep on it's a 6 weeks plus 3 months continuing cycle forever. Allow you to keep the property empty. So for this, the 4A is about the churn in a properly functioning property market. Having periods of lack of occupation is just an essential, natural, everyday feature of the market. That's what Parliament was concerned with in Reg 4A, to protect landlords to an extent from that everyday churn in the real world. It was not concerned with churn created to avoid the scheme. And then, of course, we can see from Reg 4A itself that it is subject to Regulation 5. So Reg 5 is a limitation of that. It's a limitation of that real world churn that counts. And of course Reg 5 has to be read consistently with the purposes of Reg 4 and with the overarching purpose of legislation as a whole. And if we look at Reg 5 in some detail now, we can see that it's dealing with churn because it talks about unoccupied, occupied, unoccupied. And so it's talking about the same normal turnover of uses to which Regulation 4A is concerned. And it's limiting that. It's limiting entitlement to Reg 4A if there's short repeat cycles. So it's there to limit Reg 4A and to
It's not necessarily talking about cycles at all.
well, the first
Repetition is not explicitly referring, but it's trying to identify properties where you might get short-term lettings.
and it's taking those out.
Yes.
It's a limitation on Reg 4A. Is the point I was seeking to make. It's a limitation on the situation. By definition, it's a limitation because Reg 4A says subject to Regulation 5. So normally you get this 3-month exemption once the property becomes unoccupied in the normal course of events. But you don't get that if the period of the occupation was just 6 weeks. My point is that it's not designed, and the parliamentary purpose or the legislative purpose cannot have been for Reg 5 to be used contrary to the overarching purpose to trigger exemptions. And the headline point is that looked at as a limitation on Reg 4A, it's designed to further the overarching purpose, not to provide a route to undermine it. And I would go further, that of course it has to be understood consistently with the overarching parliamentary purpose that I've been through, and not to frustrate or defeat it. And there was no power in the Secretary of State to create exceptions which have the effect for which Poll contends. Regulation making power has to be exercised consistent with the purposes for which it was granted. I then move to, unless I can assist the court on that further, I move to point 3, which is contrary to the statutory purposes.
Sorry, the power must be exercised in accordance
With the
purpose for which it was granted.
yes,
Exercised
by the Secretary of State in making the regulations consistent with the overarching purpose of Parliament in the scheme.
You're saying the Secretary of State would have had power to make regulations other than consistent with the statutory purpose. I think that's your submission.
Yes, it is, yeah. And as I'm going to show in a minute, the RMS, this is my point 3, the mitigation scheme is contrary to statutory purposes. If I can remind the court of H. Hurstwood.
Just going back to that point, the Secretary of State has had power. Obviously, no one's saying the regulations are void. You're saying it's effectively an aid to construction of the regulation.
Yes. And it can't mean what my own friend says it means. And it can't mean what my own friend says it means because the scheme that is let in by it, this RMS, is contrary to the statutory purposes. I'm going to now demonstrate that if I may. We've seen the shorthand for all the statutory purposes. I'm using Hertford 25. That's a shorthand for everything I've shown at the court. And this scheme is directly and axiomatically contrary to that, because it removes those incentives, or sorry, it reduces those incentives, which are the key purpose of the empty rates regime at all. So the empty rates regime is meant to deter landowners from leaving property empty. This makes it more possible for them to leave it empty. The empty rates regime encourages landowners to bring empty property back into use for the benefit of the community at large. This facilitates landowners doing the opposite, leaving them vacant for their own private good. So it's exactly the opposite of the statutory purpose. And it blunts the incentives which are set out in Hertford 25. And thus, it facilitates the perpetuation of non-occupation, again, directly contrary to the statutory purpose. And therefore, I repeat my headline opening few sentences that the court noted down. I then move on to occupy, which is how the courts below and in earlier cases have got round this submission. The purpose here has been put in various ways. First of all, in the agreed case summary, paragraph 9, to generate occupation. In the Trafford case, at Authority Bundle 343, perhaps we should turn this up. This is the key reasoning of Mr. Justice Kerr in the Trafford case. 343. We see at paragraph 122, we see plant the occupier's flag. Poll is in the paragraph 122. So in the present case, the business of the putative occupier is the business of occupation. The purpose of the occupation is not to store goods, it is to, so to speak, to plant the flag. And in 116, he talks, the judge there talks about the 19th and 20th century judges were not required to consider a case of occupancy for its own sake. And at 124, the thing of value to the possessor shouldn't, I see no reason why the thing of value to the possessor should not be the occupancy itself. But all of those are simply saying, occupy solely to occupy.
Occupy becomes a purpose in itself.
Occupy becomes the purpose in itself. Now, of course, this is far removed from the sort of warehouse type cases like Melody, where a warehouseman had an empty warehouse that he was willing to take goods for because the purpose there was the business of storage. There is no precedent anywhere for, in any of the occupation cases historically, for occupation, occupying to occupy being the purpose. And in my respectful submission, it's meaningless, it's tautologous, it's circular. And we can see that from Lang. My own friend Miss Lean's going to pick up on this, but just for my purposes, we just take up Lang, which is Authorities Bundle, page 83. at the bottom of that page, we see the classic statement and the 4 ingredients that they're called. And we see number 1, there must be actual occupation. And thirdly, and additionally, the possession must be of some value or benefit to the possessor. So we know that actual occupation isn't enough. We know from Lang that actual occupation by itself is not enough. The occupation has to serve a purpose beyond merely occupation. So the third limb requires an
Here it serves the purpose of avoiding tax.
well, and if we say that's the purpose, then that proves the problem. That it's just simply contrary to the statutory scheme, because it goes directly contrary to the overarching purpose of the statutory scheme. So that gives
the purpose is a bit more specific here. It's making money out of saving tax for someone else.
yes, yes. Yeah. But of course, this scheme, when Parliament legislated in section 65(2), it can't have intended to create this new concept of occupy to occupy. Because it can't have been in its contemplation. This only became a thing in 2007. It only became a thing in this scheme for the purposes of this rate mitigation. That purpose was successful in defending it in front of Mr. Justice Kerr in 2018, and it's that logic that the City of London's attacking now. I now need to go on to the rate mitigation schemes can have benefits point of my learned friend and of the judge.
Have you had enough of Poland traffic for the moment?
Yes,
Sorry, you're still on your heading 3.
I am. Yes, because it said well, occupy to occupy isn't necessarily inconsistent with the statutory scheme because it can serve a purpose, and that actually rate mitigation can be a purpose. And this is the judgment at page at 86. Charles Bagot, sitting as a Deputy High Court Judge, at page his judgment at paragraph 86. He says it's not obvious that interim occupation schemes, interpolating for rate mitigation purposes, are automatically or even necessarily contrary to Parliament's purposes. They could even bring benefits. See, for instance, the observations of Norris J in the PAG case. Now, this is a PAG case in 2015 at Authorities Bundle 22. Now, if we go to Hell, this was a winding up case, I should have said, for a company running a Hurstwood type scheme. And if we go to Hell's 9, the judge had to consider under that statutory scheme for winding up, he had to consider the just and equitable ground for winding up. This is page 289. And he found that he couldn't conclude on the evidence or in principle that mitigation schemes like this, like the Hurstwood one, was by its nature contrary to the public interest. It would not in principle be right for the court in one case to resolve what was essentially a far-reaching economic and political question. question. That's sufficient for my purposes there. So that's not the same question as this court is faced with now. This court is faced only with the question whether such schemes are within the ambit of the statutory purpose. It's not concerned with a wider question of what the court might think is just and equitable. And that means, sorry, that's fundamental, because Parliament has conclusively opined on what is in the public interest through the legislation. That's what legislation is. It has decided that liability for empty property rates is in the public interest. And if we look at the way the judge dealt with this in PAG, at paragraphs 57, well, 56 to 59, you see a weighing up of the legislation versus other factors. That's a misconceived approach for what the purposes of this case today.
So you're on page.
Page 302, paragraphs 56 on to 59, and then with the conclusions at 60.
Thank you.
And the evidence, on the one hand, there was the amount of money that was in issue. Didn't turn on the statutory purposes at all, this. And then at 58, it looks at the problems that arise from business rates, empty business rates. And then at 59, it talks about impressive evidence that looked at, if one sees the example that's given, Mr. Cook explained that before a landlord could refurbish premises, it was necessary to take back units that were in occupation, but it was not possible to obtain possession of all units simultaneously. Accordingly, some units had to be taken back and then held void pending assembly. He said that using a mitigation scheme in respect of those units lowered the cost of refurbishment and therefore encouraged the landlord to go ahead. Well, that's been in place since, I mean, that might go to the public interest balance that he had to do for winding up. It doesn't go to statutory interpretation of the regulations here. One has to find something in the regulations to allow an extension, and I've already been through that in some detail. And in any event, the very same scheme that Mr. Justice Norris seemed to be accepting wasn't contrary to the public interest, was found to be ineffective under Ramsay on a matter of statutory interpretation in the authorities bundle at page the bundle 32. So it's a completely different issue. The authorities, but the PAG scheme is effectively on the 12th of September 2025 at page 521 was found to be ineffective because it was contrary to the statutory purposes.
Does that apply Hursford? I assume it was.
Yes, that's a Hursford analysis, right? Yes. And it was a predecessor, I think, to the Emerald Shaw case. I think it was a predecessor because it came to decisions such as it wasn't limited to an unusual situation, didn't require unlawfulness, and so on. So it was a precursor to your relationship to Emerald Shaw case. So that point gets nowhere. We look at the statutory scheme. Is it consistent with the statutory scheme? Clearly isn't consistent with the statutory scheme, and 15 doesn't help. I therefore move, please, on to the fourth point, which is the Ramsay doctrine. And I do deal with this under the three heads. First of its ambit and application here, and then
Everything you've been saying is Ramsay.
It is everything is Ramsay. Yes, I was going to take this quite quickly.
Yeah.
I'm very
particularly the point you've just been talking about, but all the whole discussion about that. And indeed, the point we might come back to, which is when we get to round two, to what extent that really
Yes.
Your point about circularity,
Circularity.
you've already raised it, I think, in relation to ground one.
I'm not denying there's a significant overlap. I think there's a different conceptual framework for the decision in ground two.
Okay, well,
But-
we'll come
but,
back to that.
I'll take my ladyship's indication that, and obviously the court, at least Lady Justice Falk and Lord Justice Holgate have had to grapple with Hurstwood in detail recently, and so I wasn't going to spend much time on it. My learned friend in 99, paragraph 99 of his skeleton, doesn't call into dispute any of the principles that I've set out in the skeleton. And I do note that Emerald Shaw then effectively, much more eloquently, elaborates on the same principles. And I can't find any distinction between what I've said and what the Court of Appeal said in Emerald Shaw. Can I take that, therefore, as an indication to leave my skeleton argument to be read on those on the Ramsay principles?
Well, I'm aware at a high level of what the Ramsay principles involve, but if you're saying can the skeleton argument be taken as read, better have a look at it again. So just pause for a moment. Which paragraph?
Thank you. If we could go, please, to the it's from paragraph 42 through to 52.
Yes.
I would appreciate the opportunity just to pull out three points from it. I say the doctrine is very clear, and the force of the doctrine, I can illustrate from three examples. First of all, in Hurstwood itself, a purposive approach to person entitled to possession meant it did not bear the meaning which was well settled, that's paragraph 28 of Hurstwood, well settled in property law, that had been borne for many, many years. In Altrad, the words in the legislation cease to own plant and machinery did not apply, even though the taxpayer had sold the plant and machinery, because he was later to get it back under a convoluted scheme. And in Furness, where Ramsay, effectively one of the starting points of Ramsay, effectively assist the case to Ramsay, at about the same time, I should say. In Furness, even though there was a share swap arrangement going on within the black letter meaning of the law, it was ignored. And the creation of a company to generate the share swap was simply ignored. And in all of these cases, application of Ramsay yields exactly the opposite of what a black letter reading would have yielded. And that's because
By black letter, do you mean a literal?
a literal.
I think recent authority in the courts is saying that there isn't a hard and fast distinction between literal and purposive reading. They're seamless.
Exactly. That's what should be happening. There should be happening a purposive approach, because the literal meaning and the purposive approach should be the same. But here, the legislation was read in a way which prevented, which gave effect to the statutory purpose, to Parliament's purpose.
Or otherwise, another way of putting this is to say, if you have a scheme which accords with the literal or black letter interpretation of a statute, that won't do you much good if it doesn't accord with the purpose.
Yes, exactly. That's what I was trying to say. But all of these cases are, in that sense, black letter compliance, Ramsay non-compliance, and purpose non-compliance, and so you come to the exactly opposite conclusion. And that's why I've spent probably too long taking the court through the statutory purposes here, because and to demonstrate this scheme is clearly contrary to those purposes. My second point under point 4 is the relevance of the historic occupation cases, and my short point, and I will make it shortly, is that none of them adopt the purposive approach.
It doesn't mean any of them are, with the exception of the more recent cases that consider avoidance schemes, potentially, the fact that they don't overtly adopt a purposive approach doesn't necessarily matter.
For their purposes, I agree entirely. Entirely.
They were generally cases where there was no question of
No,
avoidance.
Yes, exactly. But the reason they don't consider a Ramsay type approach is because the Lang principles were formulated before Ramsay, 1949 compared to 1982, and before Ramsay was applied in rating for the first time in 2022. But as I've already suggested, the Ramsay principles under the declaratory principle have always been the law, and so were relevant to interpreting occupy in section 21(4) right from the outset. But also, because pre-1966 there was no liability for unoccupied rates at all, there was no possible basis for anyone creating occupation for the purposes of avoiding liability. That's my skeleton paragraph 15. Hence, I return to my point that the issue of occupation generated solely for purposes of occupation simply didn't arise until 2008. It was in the context.
Well, yes. I mean, 2008 isn't a hard cut-off. That's when people, I think you're saying that's when people started doing this.
Yeah, the issue hadn't become centre stage until 2008, yes. Well, it's not a hard cut-off. The legislation meant it all the way through, but it never became, the lacuna in the cases never became apparent until 2008. The failure of the principles to catch up with Ramsay.
And just to be clear, the choice of 2008 there isn't necessarily because of a change in the rules, because presumably by then most councils were charging unoccupied rates.
Yes. Yeah.
It's just the avoidance industry perhaps.
The avoidance industry
got going.
Yes, the avoidance industry took off because of the 100% rate. So we saw that in
more to slice up.
Project
More to slice up.
More to slice up, and we see that in the supplementary bundle, my lady, where I think I took my lady to it earlier, page 105, where it says from 2008 the 100% was what caused the problem. and I dealt with this in detail in my skeleton at 37 and 62, but I didn't turn those up. So all of those original occupation cases on which my friend Mr. Klinsky so heavily relies have to be read as subject to Ramsay. They haven't thought about Ramsay yet. And if Ramsay requires a different approach or an additional approach to Lang, I say an additional approach to Lang, then so be it. That's what Parliament's required. And so my headline point is the occupation cases cannot simply be read across into a post-Hurstwood world. And the Lang ingredients do not address the central relevant issue here, namely parliamentary intent.
You only need to say that if the third limb of Lang, beneficial occupation, embraces the type of business activity being conducted in this case.
Yes. Can I then move on to my third point under this heading, the ambit of Ramsay doctrine?
Sorry, just a minute.
Apologies.
Yes.
I was then, under this heading, I was also going to look at the macro cases because they relied on, and my short point in respect of those is that they are all again absent Ramsay.
So you put in that category macro, Trafford.
PHE and Sterling. I'm not saying
Is there
I'm,
a Harlow one as
no,
well?
that's the Public Health England one. That's why I call them Public Health.
Oh, that is.
The
Macro, PHE and Harlow, Trafford, what's the fourth one?
Sterling. Now, in macro, I needn't take the court through macro in detail, but in macro, this was a box shifting scheme with a purpose. In macro, this is at page 258. The district judge in the magistrates' court had relied on fairness. You can see that at page 258. So he was trying to apply a Ramsay approach. But if we go forward to page 262, counsel for the rating authority didn't rely on fairness. That's at the end of paragraph 28. And the court said, that fairness was, in my judgment, a very different case which involved fiscal consequences of a preordained series of transactions intended to operate as such. He accurately summarised that the principle, in my judgment, is of no assistance in considering the question of intention in this case. So basically, the court, His Honour Judge Jarman, just dismissed reliance on Ramsay in macro. If we go to the next tab, we get the Sterling case. This is the Wi-Fi messages, and we can see that at page 271. There's reference to the macro case at the bottom there, and no reference to any of the Ramsay type principles. And the case is silent on the Ramsay type principles. And in Trafford, the judge thought about Ramsay at 75 and 76. This is a page 336. I just need to pause because paragraph 75, he talks about the Rosendale case, but that was the Rosendale case in the High Court, which was overturned by the Supreme Court. And then he said he rejected the possibility, this is in paragraph 76, rejected the possibility that the billing authorities might defeat the effect of the schemes by application of what has been called the Ramsay principle, which is not relied on in the present case and which I will not attempt at my peril to paraphrase. And we can see that he adopted exactly the opposite approach to Ramsay at paragraph 118. Modern cases on rates avoidance, so he refers back to Maxwell and Rosendale, stand for the proposition that where transactions are genuine and mean what they say, their meaning and effect and the general law must not be distorted or manipulated in the name of morality, so as to prevent avoidance of rates. So this failure to understand Ramsay led this to being articulated as a matter of morality. And that was the same position back in Macro, in the last sentence of Macro, at page 268 of the bundle. The last sentence, it has often been emphasised that the court is not a court of morals but of law. So they're all adopting a black letter approach and not Ramsay, and applying and saying, well, we can't judge it on the basis of morality, but morality's got nothing to do with it. This is all about statutory intention, statutory purpose. And the court, Lord Justice Holgate in Emerald Shaw at paragraph 81 confirms that this is at page 565 of the bundle. At paragraph 81, the court refers to Principled, the 2018 case, and the application of the Ramsay principle to schemes for avoiding liability, in particular on unoccupied property, was not an issue in that case, and the judge's statement predated the decision of the Supreme Court in Rosendale. In any event, the Ramsay principle is a principle of statutory interpretation based on the identification of the purpose of the legislation. The application of that principle does not in any way involve the court distorting or manipulating the meaning and effect of a transaction or arrangement in the name of morality. In effect, as I understand Lord Justice Holgate, he was saying it's all about statutory construction. My point 5, therefore, is the class of cases to which Reg 4A and 5 apply, and consistent with my submissions on Reg 4A and 5 already, the class of cases to which they apply and which occupation applies, sorry, the class of cases to which Regulation 5 applies, I'm sorry, I'll start again. The class of cases to which occupy in Regulation 5 applies is occupation meeting the Lang requirements other than occupation generated solely for its own sake to trigger the reset.
Just say that again.
The class of cases to which occupy in Regulation 5 applies is occupation meeting the Lang requirements other than occupation generated solely for its own sake to trigger the reset. then move on to the import. Point 6 is the effect of the 2024 regulations.
Say meeting the land requirements with that exception. Would you like to answer the point that my Lord Justice Holgate raised a few minutes ago about the phrase beneficial occupation, Lang number 3?
Yes, but that's really being raised under ground 2. But yes, beneficial occupation has to be something beyond occupying. Occupying for its own sake is not a benefit. It's tautologous and circular. That's the point I was trying to make earlier about occupy to occupy.
But at this stage, you're assuming that the Lang requirements are met,
Yeah.
whereas there's a more fundamental requirement as to point about whether Lang, which of course isn't a statutory test anyway, should be understood as including as its third ingredient this sort of occupation.
That's another way of putting the same point. Yes. Can it properly be understood as covering this sort of occupation? And my lady has my answer to that point.
That's why I was wondering about your formulation, other than. That could be taken to imply that it is included in what is.
Okay.
I suspect you didn't mean that.
I didn't mean that at all. I meant that beneficial occupation in Lang 3 doesn't include.
Yes, that's what I had in my mind.
I'm sorry I hadn't articulated it in that way, but yes, that is the point. So we then move to the 2024 regulations, and this is my point 6, and whether they can aid the construction. It's necessary to take a little bit of time just going through what the process was. But I've got 4 answers to the point raised by Lord Justice Bean. Firstly, the legislation is not ambiguous. That's my first point.
2008.
2008, and going right back to 1966. It's all of a piece. Secondly, the 2024 regulations do not fix the meaning of occupy. All they do is extend the time if there is occupation. Third, the 2024 regulations cannot fix the meaning of occupy because it's fixed by the primary legislation. And that's why I went through the statutory history in more detail, because the purpose of occupy has always been, the meaning of occupy has always been what it was right at the outset in the primary legislation, and it hasn't changed. So rather than, so my learned friend has to point to a change in the meaning of occupy between 1966, when it was in primary, and when the same words went into secondary. And the fourth point, that section 65(2) does not give the ability to make regulations to fix the meaning of occupy. It tells you what the meaning is, and it looks elsewhere. And finally, regulations which fix the meaning in the way intended for would be unlawful, because they would be outside the statutory purpose, the parliamentary purpose. To make good those points, could I start just by whizzing through the supplement, the material on the consultation on this, which if I'm not permitted to, then of course I understand. But if we can just show how this all comes about. This is supplementary bundle page 44 and following. And if we can start at 47, second paragraph. Small minority who seek to exploit the business rate system. Sorry, page 47, second paragraph. Small minority who seek to exploit the business rate system either through false reporting or through contrived means which circumvent the spirit and intention of the law. So the Secretary of State was saying this is not Ramsay compliant. The scheme is not Ramsay compliant. And if we look at the next page, paragraph 1.4, bending the rules to gain a financial page 48.
Sorry.
1.4, bending the rules to gain a financial advantage which Parliament did not intend. 1.12, sorry. Active and public promotion of rate mitigation strategies by third-party companies, that's here. And, oh, sorry, I should have said in 1.11, artificial or contrived occupation. .5 at page 51. Sorry, 2.4, the scheme is not working as intended. So again, saying that these schemes are contrary to the statutory purpose. Sequential.
2.5.
2.4.
2.5.
So apologies, page 51. Is not working as intended. And 2.5, no statutory definition of what constitutes occupation of a property and minimal occupation, possibly of no material benefit to the occupier, may be sufficient to allow ratepayers access to a further rate-free period. And then we get the proposed reforms.
Interestingly enough, it says of no material benefit to the occupier.
To the occupier, yes. I was going to come back to that point, yes.
In 2.5 in the third. Up until now, the discussion has been about the benefit to Pole.
Well, the benefit of the occupation to both, I suppose, would be said to be the rate mitigation, because the occupier gets the rate mitigation later for the.
Yes, that's the rate mitigation, but it's not full. It's not. I hadn't understood to be part of the benefit of the occupation by Pole during the 6 weeks.
No, and I've made submissions as to it being.
I don't quite understand what that paragraph is. You've got to be a bit careful about this sort of text because
I'm just.
I'm not statute.
No, but I'm just showing how it emerged. I mean, and basically, what happened was that there was some consultation on three possible adjustments. One was changing the reset period to reduce the incentive to abuse. The second was limiting the number of times you could rely on Regulation 5. And the final one was adding conditions in Regulation 5. For example, saying 50%, you've got to be occupying 50% of the space or something. That's at paragraph 2.17. There were no proposals to change the meaning of occupy. Maybe add conditions to what occupy already meant, but nothing to change the meaning of occupy. And when the consultation responses come back, we can see this, the page 64.
How do the responses help us?
No, this is the government's decision to legislate. I'm very happy to move on to the actual statutory material. but the responses are that the councils were concerned that the case law had legitimised the schemes, and the Secretary of State was seeking to mitigate the effect of the schemes by reducing the incentive. That's all he was doing. He was not seeking to change or define the definition of occupy.
No, but well, we probably can look at the ministerial forward in this document, page 61. It says that change in the reset period. This will disincentivise the widespread practice collectively known as Falk shift.
Yeah. So it's direct. So it's disincentivising it by extending the period for it, not by changing the definition of occupy in Regulation 5. And not
If you change 6 weeks to 13 weeks, presumably the rate saving goes down from 67%.
yes, to 50%.
Do we know what the number is?
To 50, it's 50%. It would become 3 months. 3 months. You'd get, so over the 6 months you save 50%.
50%, out of which you pay whatever
Yeah.
percentage, etc.
Yeah. So presumably the lease is now, say, 13 weeks rather than 6 weeks. Presumably.
Yeah.
But so there was no change to the meaning. There was no statutory intervention proposed or carried forward to the meaning of the word occupy. It was to the period of the occupation. There was no attempt to change what occupy meant.
But presumably there's a delicate balance going on here, because there are, you may not necessarily in the real world have repeat short periods of occupation, whether it be 6 weeks or 13 weeks or whatever. You may have, from time to time, a short letting.
Yeah. Or somebody goes bankrupt very
It
quickly.
doesn't involve this recycling concept at all.
No. And
So if you can obviously adjust upwards.
yes.
6 weeks to 13 weeks, 14 weeks, 15. But there are other considerations as well.
And there is, in this document, there is talk of the balance because of landlords who are innocent, in
The
inverted
hope
commas.
was that by increasing to 13, that would make it economically less worthwhile
attractive, yeah.
to pay your RMS.
Yes, exactly. Exactly. That was the point. It was hoping to do that. It wasn't attempting to or purporting to change the statutory definition, the meaning of occupy. In terms, it wasn't. So therefore, I come to my submissions. The case law that my Lord Justice Bean has provided, it is all of it, as the court's got redundant here, all of it is where the subsequent legislation makes one interpretation of the former legislation inevitable. All of it is where the subsequent legislation makes the interpretation of the one interpretation of the former legislation inevitable. And I'm going to take the court through the cases very briefly. The first one is Attorney General and Clarkson. The question there was at page 162 on the top right hand, at the top, so page 8 of your bundle. Right at the bottom, the legislation at the time talked about a property that was settled by will, and that was Section 5 of the Finance Act 1894. And the question was whether anything contingently settled was within that.
Mr. Forster, you can take your own course. It might be a more efficient way of looking at this bundle to start with Bennion, who summarises the case, and then maybe the
I'm not
as
sure
to what you can get, for example, out of Clarkson. There's stated at Bennion, page 101 of this bundle. You might be able to save time, but if he's inadequately stated finding from the case, then we may have to go through the case.
Yes, I'm very happy to do that, my lord. But the well, if we go to page 101, then the settled. The question was contingently settled property within the term settled by the will, and a later act, the section 14 of the Finance Act 1898, made it clear that contingently settled was settled by the will. The section 14 only made sense on the basis that contingent settlement counted, because otherwise section 14 would never have been triggered. That's the point I was going to make on the case. I'm not sure you can get that from page 101.
No, well, forgive me, I probably shouldn't have said anything, but we may not need to dive into the meaning of settled estate duty under the Finance Acts of 1894 and 1898. If we do, we do.
No, but my point, my lord, is that all the principle that my lord pointed us to it arises when there's ambiguity, when there's two possible constructions, and where the later legislation is only explicable by reference to one of them.
Yes.
And so in all of them, in all of the cases that we put before the court and my lord referred to, all of them are on the precise wording. So they're looking at the precise words of settled by the will. Is it contingent? Well, we know from later legislation that it was meant to be contingent.
Well, they actually use the word contingent.
Yes.
Yeah.
Yes. And then in
Read that two ways, I think.
And then in Hang, the question was profits arising or derived from Hong Kong, and there was a later bit of legislation deeming the particular things to be derived from Hong Kong, and that was only explicable on the basis that they weren't previously derived from Hong Kong. So it was a straight answer to the statutory construction. The later legislation was a straight answer to the statutory construction question. Similarly, in News Corporation, the way the later legislation worked told you that newspapers hadn't been previously exempt, because it went from being because of the changes in the definitions. And the same basic principle in Walsall as well. So all of them are where the legislation at the same level, that's important, is only consistent with one interpretation of the former legislation.
I mean, you can regard this as just a narrow exception to a more general principle, which is you don't construe earlier legislation by reference to later legislation.
I was going to say, it's a very narrow exception if there's ambiguity, if the new legislation clearly resolves the ambiguity on the words. And so, and therefore I say it doesn't apply at all. So first of all, I'll make my 5 points if I may.
Okay. Would you like to make them at 2 o'clock? How far do you think you have to go in terms of time before you will be able to mislead?
Pretty short.
Court riseth able.